Today I'm joined by Professor Elise Bant. Professor Bant holds a joint bachelor degree in Arts and Law with honours from the University of Western Australia, as well as degrees of Bachelor in Civil Laws with distinction and Doctor of Philosophy from the University of Oxford, where she was a Clarendon Scholar. Elise practised in commercial litigation with the national firm Freehills before joining the University of Western Australia Law School. She subsequently taught at Oxford and was a visiting scholar in Portugal before joining the Melbourne Law School in 2008. Elise rejoined UWA Law School in 2020. She is a professional fellow at the University of Melbourne, fellow of the Australian Academy of Law, and a consultant to HFW Australia. Today, I will talk to Elise about her concept of systems intentionality, a new model of corporate responsibility. Professor Bant, thank you for joining me on the Counsel Connect podcast.
Thank you, Marcus.
One of the reasons I wanted to talk to you was in relation to your work on systems intentionality. You've described there being a quiet revolution in the corporate law space in Australia, and a recent pinnacle of that is the High Court's recognition of your work. Could you just explain to me what's meant by the systems intentionality concept?
Thanks, Marcus, and thank you for inviting me here. My model of systems intentionality responds to the fact that corporations are recognised in the law as legal persons. So like you and me, they can have responsibility for their actions. They can, unfortunately, commit harms, and they can commit those harms with intentions and with knowledge. But the trick is, how do we know, as a matter of law, when a corporation forms an intention? How do we prove it? Corporations are artificial legal persons. They don't have a natural mind. And so the law has created a set of rules that deal with the attribution of corporate states of mind. And in general, that's done through a fairly simple mechanism of looking for a responsible individual within the corporation whose mindset can be attributed to the corporation. And I call that the game of Where's Wally, because we're looking within potentially a very large and diffused corporation for one responsible individual whose mindset can be attributed to the corporation. That's fine for small, hierarchically organised companies, but very, very difficult for modern, diffused, complex corporations with perhaps algorithmic and automated systems operating core corporate functions. In that context, how do we find the corporate mindset? And so my model, systems intentionality, explains precisely that question, geared for modern complex corporate structures.
Does some of your concept then derive from looking at the inadequacy of finding a culpable person or persons in the current framework, for example, where a claimant or a regulator may try and point the finger at a board member or a collection of board members and look more broadly at the corporate's responsibility?
So my interest in this all began with the Banking Royal Commission, actually, and the fees for no services cases. You may recall a whole pile of banking financial service providers were charging fees for no services through automated fee deduction mechanisms. And one particular set of scenarios caught my eye, because in these cases, banks were charging customers for life insurance fees even after the customers had died. And this misconduct had carried on for, in some cases, over a decade, with the grieving families of the deceased customer calling the bank and saying, my husband, my wife, my father has passed away, and yet you're still deducting fees. And the bank's response would be, oh, well, we'll investigate, and they'd keep taking fees in the interim. Now, when this came up before the Banking Royal Commission, a number of directors and senior managers were called before the Commission to explain how this could be so. And in every single case, the directors said, well, we personally as directors, we didn't know. So they're the normal director mind and will. That's where we normally look to start for how corporations think and what knowledge they have and so on. What do the directors know? What do they intend? But the directors knew nothing. And of course, the directors also said, our employees, all hardworking and honest. And that's probably true. They're hardworking, honest, natural employees. But this was a corporate system of conduct that was deployed through an automated system. And my model explains that when you look at the system design of that automated fee deduction process, some important states of mind on the part of the corporation become readily apparent. And we can see that the corporation has made choices through its system design. The system design, if I put it the way I put it in my model, is a corporation manifests in the sense of both reveals and gives effect to or instantiates its states of mind through its systems of conduct, its policies and its practices. Now, when you looked at the automated systems in those fees for no services cases, what do we know? Well, we knew that they were automated systems, that they were deducting fees for life insurance. This meant that the customer for whose those fees were being taken, some of those customers would inevitably die. That's the reason why there was this automated system in place to pay life insurance. And yet, the fee deduction system was deployed without any mechanism for stopping the fee deductions when the customer died. Now, that's not an accident. That's a choice manifested through system design. This was a set and forget automated system in every case, which was deployed knowing that inevitably it would result in unlawful takings from deceased customers' accounts. Now, we know this is knowledge that was patent on the face of the system, corporate knowledge shouted in the system design. This was intended conduct, it was dishonest. So we can draw a lot of insights from the corporate mindset from just looking at the patently obvious system choices that are there on the face of the system as designed.
A couple of points I'd like to unpack there, and probably the first I'd like to make is that the concept is not designed to focus just on automated systems, but it's clearly applicable in the current world that we live in now. It's underpinned by systems, practices and policies. And as you've mentioned, traditionally we look at attributing liability to a person or persons who direct the mind and will of the corporation. And there seems to be a natural progression in your concept from the Healy origins of case law, and you've mentioned that sometimes a board will throw their hands up and say, well, this was either they plead ignorance or that they've deferred responsibility to management. Now, the law has recognised for some time that that's not acceptable, and there's been perhaps a more recent iteration of that in the Star Entertainment case. So what was it that caused you to feel that this area of law needed to be explored or expanded? Why don't the current concepts that exist to protect from corporate misconduct, why do they not work as they should do? Why do they need expanding?
Well, I think it comes back to that idea that many corporate structures diffuse knowledge amongst teams of employees. Perhaps automated systems are in play. There may be delegation of different decision-making tasks. The role of standard operating procedures is actually to remove discretion on the part of individual employees so that they follow a certain set of prescribed behaviours to realise the corporation's purposes and goals. So standard operating procedures are a classic example of where the normal approach to corporate responsibility start to fall away, because when we look at why it is that any individual is performing their role on the part of the corporation, the short answer is because they're following the standard operating procedures. They're following a practice or a system of conduct. They're part of that system. But individually, none of them may bring an independent mind to bear as to why. So the individual employees may be honest and hardworking and actually have little understanding of their role within the broader system. Now, in that very simple context, our responsibility rules start to break down. Unless we can show that there was a particular manager who can be identified, for example, who designed the standard operating procedures in such a way that with the intention of producing some harmful outcome, for example, avoiding some legal obligation or, undermining workplace health and safety protocols or something like that. Unless we can find Wally and bring them to account, and so through them the corporation, then we're lost. And so we have, within corporations, information silos that develop. There's a lack of connection between relevant teams, and these sorts of responsibility barriers are almost encouraged by our existing attribution rules. The more siloed and more diffused and more separated individuals are from having an overall holistic understanding of the corporate purposes that they're part of enacting, the better it is for corporate responsibility. So I think that's the kind of misconduct that my model is particularly aimed at addressing, the diffused knowledge that we see common in complex modern corporations, are often diffused across individuals, across teams, perhaps across jurisdictions, and often over time as well, through generations of employees who come and go, and who, it's almost impossible to track one single individual who can be scapegoated for the purposes of holding the corporation to account.
Yes, I mean, that's been the traditionally desired approach, is to have a scapegoat, to have somebody who you can point to, partly for policy reasons, and partly to satisfy the aggrieved, to have an individual at the end of the hook that they can point to and be seen as being held responsible. But it seems that
I should say, Marcus, that on my model, it's not that individuals stop having responsibilities. It's just that we think about individuals' responsibilities as being personal and positional. The positional obligations they owe, for example, to the corporation as an employee, to be, honest and loyal and, operate in accordance with their contracts and so on. They may also owe obligations to parties who are harmed by their contribution to the corporate misconduct, because they may be, if they're involved knowingly and they're actively facilitating the misconduct and they're in a position to make a difference, they could be an accessory to the corporation's misconduct. So the role of individuals is not left out of the story. It's just that we sort of maintain a conceptual and legal difference between the corporation's own organisational responsibility and the individual's responsibilities for their own acts.
So it doesn't undermine or negate the current liability framework for officers, for managers, or individuals at all. It supplements that by reflecting the way that modern corporate life is increasingly operated by larger, more complex systems. We just have to look at some of the corporations that exist now, including the biggest corporations in the world, that are bigger, more financially wealthy than some small countries. But I think that demonstrates a broader pattern to a degree. There are still the colloquial mum and dad corporations.
Yeah, there are.
But the aspiration of most corporations, any corporation, some would argue, is to make as much money as it can for its stakeholders, which generally points to a growth model, which generally points to a devolvement of responsibility, different silos, different segments, and making it more difficult to attribute responsibility. So with that in mind, Elise, where do you see this concept sitting within the current legal framework?
So I think my model is not inconsistent with existing approaches. Of course, corporations have default decision-making structures. A corporation is an artificial entity that has no natural mind, so it has to make decisions through some mechanism. And that will be, to start off with, the board of directors or the directors. And there will be other organisational structures that are default structures. There might be shareholders in general meeting and that sort of thing. But those sorts of structures won't do for all of the vast variety of different behaviours that a corporation needs to engage in, a corporation of any size. So that's where you get more, you get other systems developing, day-to-day systems of conduct, policies and practices. In terms of, so I don't think it's inconsistent with our existing attribution rules. It just supplements those default decision-making structures by pointing to other structures and saying, look, we can see the shape and design of those structures, objectively speaking, and construe them or interpret them to understand corporate mindsets.
Can I give an example there? So, for example, the recent Productivity Partners case where Justices Edelman and Gordon effectively endorse this concept when looking at unconscionable conduct. Is that a good example of how and where this concept currently sits and exists as an application?
So it was a wonderful example of a predatory business practice. So you had a vocational education training college, the Captain Cook College, that had third-party recruiters who were themselves sometimes natural persons and sometimes corporations. They would go out into the field and sign up students from remote and regional communities. The aim of this was to generate fees through, at census date, the Commonwealth government at that time would pay the college the entire course fees for any registered students as at the date of census. And the recruitment agents were incentivised to try and recruit as many students and retain them for census as possible, because their own fees were commission-based. The more students they signed up, the better it was for them. Captain Cook College understood that this combination led to misconduct in the field, because there had been a very, very long history of misconduct by third-party recruiting agents exerting pressure and misleading conduct and so on to get what the High Court described as unwitting and unwilling students, unwitting and unsuitable students to sign up to courses that often they had no means of finishing. For example, some of the regional and rural students were signing up for online courses when they had no access to regular internet coverage and that sort of thing. So the college had in place two protective systems to counter the problem of third-party recruiters. They would call the student. If the student hadn't engaged online within a certain period, they would check the student had understood that they were signing themselves up for, a large fee, to carry out the particular course of study. They would check that they had ability to be able to continue with their studies and so on. So there was a call, outwards call. There was also a system of unilateral disenrolment that the college would do just before census date to weed out any students who hadn't engaged in the course. Now, systemically, both those two protective processes reflected a certain prudence and responsibility on the part of the corporation, but they were undermining the corporation's profits. So what did the corporation do? Well, it decided to remove those protective processes and its profits skyrocketed. Now, the corporation said, we didn't intend to take advantage of those delightful students. We didn't mean to sign up unwitting and unwilling students. But Justice Gordon and Justice Edelman, and Justice Gordon had Justice Stewart and Justice Speech Jones separately agreeing with this aspect of the decision, said, no, the decision to remove those protective systems so that the overall design of the registration system for students changed fundamentally, that was an act of deliberate corporate choice expressed through the removal of the systems, and there could be only one outcome of the removal of those protective systems, and that was you got more unsuitable students enrolled for longer to their detriment. This was a choice to adopt unsuitable students' enrolments in order to increase corporate profits. And that was plain on the face of the decision to remove the protective systems, protective processes, so that the overall sign-up system changed.
Which is interesting because directors would say, well, we're maximising profits for the company, we're acting in the best interest of the company, we're doing our job.
Yeah.
The
Justice
recruiters
Edelman would say the corporation has no interest in acting unlawfully.
Yes,
Yeah.
And that's probably where I'd like to come back to in terms of the recent Star Entertainment decision, the obligations that officers and general counsel have to make sure that a company is not acting unlawfully. But I think that's a good example because there is an identifiable perhaps decision there whereby a company has decided to remove some protective measures, which has had this implication as effectively acting unconscionably. But as you pointed to earlier, Elise, there's companies that now span decades and generations. It's not always going to be so easy as just to point to a single identifiable board position when there's perhaps a longer standing, systemic, siloed or holistic set of policies or systems that creates wrongdoing. So the decision we just talked about is concerned with unconscionable conduct. Is there broader application of this concept within current laws?
Yes. So the model itself builds on Australia's quite distinctive corporate culture provisions, which are in our Commonwealth Criminal Code, section 12, part 12.3, I think. And those iconic provisions tried to set up a framework for corporate responsibility in systemic terms. And what my model does is pick that up and then effectively make it a more useful doctrinal analytical model so that we know precisely how a system of conduct bears on the particular mental states that are required for corporate responsibility. And they're usually things like general and specific intention, knowledge of certain types. Mistake is an important thing. The model has exculpatory as well as inculpatory effect. You know, we can see when a corporation is mistaken. And I'll give you a simple example because this is not something which is counterintuitive. Once you get the hang of it, it works quite easily. So if I was trying to work out what a cook was doing in the kitchen, I would observe the cook and I might notice that they are following a recipe for baking a cake. Now, by simply observing the system of conduct in which the cook is involved, I would know a lot of things about the cook's state of mind, that the cook means to engage in a process of baking, that's a general intentionality, that they understand certain things, they know what flour and eggs and the process of beating are, because otherwise the recipe won't work. The recipe might be of a nature to produce only one outcome, a chocolate cake of a certain type. Now, of course, with a human cook, we can see their state of mind manifested through the system of conduct in that way. But of course, they have a natural mind and they might have knowledge and memory and intuition which assists with their decision-making processes. Now, corporations have none of that. They don't have the natural instincts or intuitions or memories. So everything that they do must be engaged through systems. And when you have a corporate cook involved, engaging in a process of baking or cooking, whatever it is, we can apply that same interpretive method, and it's a perfectly accurate window into the corporate mind. We don't have to drill down any further. We just look at the system as deployed and we can interpret that to reveal corporate knowledge, corporate general and specific intentions, and also claims of mistakes. So say you have a corporate cook that says, oh gosh, I meant to produce a cake and lo, I've produced pancakes. It was a mistake. Well, we can assess that claim by reference to the system as it deploys over time. So the longer the system produces pancakes, and certainly once the corporate cook starts charging for them, we know that this was simply a misrepresentation of what the corporate cook meant to do. The intention all along was to produce pancakes. Now, there are some important points that come out of that rather silly example. Firstly, that when we're assessing systems, we look at what's included, the positive elements, but also what's omitted. So, it's 2 eggs, not 4, beating, not whipping. I don't know, I'm a terrible cook when it comes to cakes, but there will be choices that are instantiated in an actual system of conduct as deployed, and they're important to note. Secondly, there's the fact that systems tend to operate repeatedly over time, and how a corporation responds to a system of conduct is very important. So this is Brent Fissey's idea of reactive corporate fault. The longer a system deploys without change, the easier it is to understand that this is the system of conduct as intended. This system is operating correctly according to its terms, and in that way it's realising the corporate purposes. So when we think about the fees for no services cases again, these systems were maintained over very, very long periods of time. So they were working perfectly as intended. The default setting there was to keep taking funds from customers until required to stop. Mm. So the system analysis works perfectly well in a range of different scenarios. We can also use it to test claims of mistake in other ways. So, for example, suppose you have a system that misdeploys and there is an immediate corrective response by the corporation. Well, that does suggest that there's been a corporate mistake. There was a systems error. The system didn't deploy as intended. So we can use that in all sorts of different case scenarios.
I'll take your pancake example and,
yeah.
and test some of that. So taking that example, let's say in the corporate sense, there was a pancake producer and over time it was producing pancakes that gave people gastro, and there was a harm committed in the ordinary tort sense. So you'd examine the systems that went into the process of making the pancake, the policies behind it, etc. And looking at the example of mistake. If, for example, for every 10,000 pancakes produced, you found an instance of one or a handful that made people unwell, and you perhaps identified that there was a mistake not attributable to the systems, the rules and the policies that sit behind it. Is there a challenge posed for earlier mistakes, or does the same principle apply where you just look at the systems, policies and procedures that were set up to first instigate the process? So using a pancake analogy, if my first pancake gave somebody gastroenteritis, does the concept apply applicably there in looking at the origins of what went into making that pancake?
So there's no doubt that my model encourages competent systems design. So when you're starting up business and you're putting systems in place, the model proceeds on the basis that a system as deployed, not the glossy ones that are on the website that say, oh yes, we care for our employees and our customers and so on, while the practices are very different. We have rats scurrying around the kitchen or something like that, and there's an obvious health hazard involved. You look at the system as deployed, and if that system as deployed results in harms, then part of the model is to encourage systems to have audit and remedial mechanisms baked in. So set and forget systems are not prudent responsible systems. They're potentially reckless. They're certainly undesirable. My model, when it looks at a system of conduct, it will say, well, the system of conduct is both those proactive and omitted elements we discussed it earlier, and those omitted elements may include audit and remedial mechanisms. If there are none of those in place, then there's a certain level of corporate culpability right from the start. Now, of course, there may be errors when you're first rolling out a system, but it's all about prudent responses. None of this is brain surgery. No director or manager worth their money would be surprised to hear that prudent, responsible systems design involves audit and remedial mechanisms. This is, of course, what Crown Casino had problems with its anti-money laundering processes, which, frankly, couldn't be better set up to facilitate money laundering. I'm not going too far off the finding of the Royal Commission in Victoria in particular, that pointed out that for a very, very long time their anti-money laundering processes actively facilitated money laundering, and a big part of that was that there was a complete omission of any internal audit or remedial mechanisms geared towards anti-money laundering. And for a casino, of course, that's extraordinary. So, and these are corporate choices. These are not the way it has to be.
Does that signify a mind shift change for managers, officers, and in-house counsel in particular? If there's a growth in the judicial recognition of systems intentionality as a foundation of corporate liability, does there need to be a different attitude to the approach in audits? You're not just looking for when things go wrong. You're looking at underlying systems and if they function appropriately.
Correct. And the important thing is that in even the best designed system, and systems sometimes are actively engineered and designed, and sometimes they evolve organically. That's why I have practices, systems of conduct, policies and practices. Practices evolve organically. They're customary behaviours that developed in a corporation over time. Now, even the best practices or the best systems, because circumstances change, they may well themselves need to change in order to remain ethical systems. And we see that a lot with frankly, payroll systems where there's some change in the law or where there's, some sort of change in surrounding environments, and the payroll system just rolls on in its predetermined way without adjustment. Now, unless you have audit and remedial processes in place, there's only one outcome of that, and that is unlawful and potentially unethical conduct. So it really does put an onus on corporations, large and small, to work through how to make sure that these systems that they deploy, which after all are usually all about economies, we get rid of the bookkeeper and put in the automated payroll system because it's cheaper and more efficient and better for corporate profits and so on and so forth. Well, there comes a cost with that. You have to have the appropriate audit and remedial mechanisms for the inevitability that because external circumstances are not constant, they change, they're dynamic, the system itself will need to be adjusted over time.
So would it be fair to say it's nothing new in the sense of having to manage a corporation to avoid committing wrong and harm? It's just, is it a broader, a more onerous obligation now if we adopt this system, or is it how it should have been in the first place?
I just think it's how it always should have been, but it's what it's doing is it's providing an intellectual architecture for explaining why it is that the excuse, the narrative of, it was a systems error, it was an administrative failure, we didn't mean it, so on and so forth, is less likely to hold water. It's more likely to be probed because, if you deploy a system of conduct that operates in a critical area such as employees' payments, for example, superannuation payments and those sorts of things. And you do so without proper systems design, including the audit and remedial mechanism, then that is a considered choice, and that looks very bad responsibility-wise. I think for managers and directors, this can be a useful tool as well. The idea of corporate culture, for example, has had a powerful impact on Australian commercial and legal life, but it's always been a little bit difficult to nail down.
So you've been very diplomatic there. So on that point, the Law Commission of England and Wales, who are looking at the flaws in their system for corporate criminal culpability, were relatively scathing of our concept of corporate culpability and corporate conduct, whilst it should be said recognising the utility of systems intentionality as a concept. I think they saw the criminal code provision of corporate conduct effectively as quite impotent, quite vague. It's not held too many to account so far.
That's true, but as a governance tool, not as a liability tool. As a liability tool, I'm afraid corporate culture has been a dreadful failure. But as a governance tool, the idea of promoting positive corporate cultures has been quite a powerful one. And there's a whole cottage industry out there of corporate culture experts who will come in and diagnose your deficient corporate culture and fix it and so on. And some of them take very individualised approaches. They'll go and ask the employees, how do you feel in the workplace? What do you see the corporate culture as? And for me, that's of limited utility. Frankly, if someone came and asked me about my corporation's culture, I would have some fairly firm views, but they may not be reflective of the organisation's behaviours and purposes and so on as a whole. Systems intentionality sees corporate culture as the overarching policies of a corporation, the values, the purposes, the overall beliefs of a corporation that nudge the daily practices. So in the case, for example, of the Crown Casino, Commissioner Finkelstein said that Crown had a profit at any cost culture. And what that means as a kind of overarching policy is that when you get to those leeways of choice in a say a standard operating procedure or just in an everyday practice in the workplace, if there's a choice between going one way and another, that you'll take the one that leads to most profit, notwithstanding perhaps legal requirements and notwithstanding potential harms. So we saw that in the case of the responsible gambling policies, which the glossy ones on the website looked great. We love our patrons and we look after them, we take care of them and so on. The profit at any cost policy, though, meant that staff were trained to keep people gambling for as long as they could without break. And those are the sorts of practices where we see those high-level policies instantiated on the ground in the training practices for the staff who are being who are inducing or encouraging punters to stay at their slot machines for as long as they can.
I want to come back to the point we were talking about before in terms of whether that then does represent a shift in attitudes, responsibilities and practices for in-house counsel and for directors, because historically as corporations have grown, there has been a devolvement of responsibility, of practices, of specialisation, because it's factually impossible for a small selection of boards to stay across the minutiae of all details.
Yep.
And historically the argument's been, well, we put in place the right policies, we dictated the right practices, there were the systems designed by lower level management, etc., etc. And as far as we're working, everything's in place for a harmonious organisation to work. Yep. I think this then requires a combination of looking at the realities of how that implements in practice, But the way I see it as a litigator is it does perhaps expand the need to have regard to some of the smaller details and being across more of the information, because it's the collection of the systems, the practices, the policies, and their effect that has to be taken into account.
So it's a really good point. So if you have ethical, lawful, prudent systems that you deploy through your corporation, and they're actually embedded, so not the glossy ones on the website, but the ones that are in play on the ground, then things can go wrong, and there may be some misdeployment, or there may be, rogue employee subverting the corporation's systems in some way. Then the trick is to have in place those audit and remedial mechanisms to be able to pick up and respond in an appropriate way. So this is not a strict liability approach in the sense that you get held responsible come what may. And in fact, the I don't know whether you're aware of the failure to prevent offences which have been introduced first in England and then in Australia. But the very idea of those models is that they recognise that prudent systems design and deployment isn't going to catch every instance of misconduct. And that's okay. You don't necessarily get hung for having had some sort of harm or problem result from your ethical, lawful systems. What you get hung for, though, is firstly the glossy ones which bear no relationship to the real life practices on the ground. This is often found to be so in cases of greenwashing and so on, where you have corporations who say, oh, we love the environment, we care about it so much, so on and so forth. And yet
the analogy to ESG where it shifted from you have to have a policy to you have to implement the policy.
Yeah,
you have to be seen to implement the policy. Yeah.
So if you have the we love the environment, and then in fact the practices all are geared around cheap pollutants, failure to clean up after the corporate business and so on and so forth. If those are the instantiated, the deployed practices, and that's where you find the corporate choices and values. That's where the rubber meets the road. So that's the first thing. You have to make sure that the beautiful glossy policies that have been vetted by legal and by HR and everyone actually get implemented. And then you have to sustain them over time through audit and remedial mechanisms. So it's a business. But that's the cost of doing business, isn't it? The bigger you become, I hate these narratives around, we're too big to ensure that we're operating lawfully. Well, that's your problem. Change your structures.
The counter is you've got more onus to make sure you're operating properly because you are
that's
bigger.
Right. You just need to invest more in your, systems designs and deployment and audit and remedial structures.
I think that's one of the outcomes, isn't it? Because you look at the Star Entertainment Group where the court recognised the difficulty of getting across 1,000-page board packs, but effectively, if you are a well-remunerated leading board member of a large corporation, suck it up because that's your role and you have to be across the detail to a certain level.
And I think the thing is that it's like corporate culture, really. I mean, board members have responsibility for the overall policy settings of the corporation. That's where the corporation's values sit, in with the board that say, well, we are going to, privilege environmental protection over, rampant profit making, for example. We're going to promote ourselves as a green business. That's the kind of choice that often is made within the corporation's decision-making structures at the top. And then the challenge is for directors to make sure that is implemented as it's carried out through the corporation. So obviously directors can't be on the ground in every place, but what they can do is require there to be in place substructures and subsystems and sub-processes that translate those high-level policy settings into reality on the ground. Now, that's a tricky job.
I was gonna say
and that's the reason why you're being paid.
Yes. That's hard, and as a commercial corporate litigator, where I see that one of the benefits of the system is everything we just talked about in terms of the corporate structure and the difficulties faced by larger, more complex corporations, is that if you're trying to analyse systems, practices and policies, that can be a phenomenal task, because some of the complexity underpinning all of this, and there may actually be no genuine misintent anywhere to cause somebody harm, but that's not going to stop an end user, a person suffering harm by reason of something that has gone wrong in terms of the operations of the company to cause it harm. And it gives an opportunity for recourse for those that suffer harm by these big organisations.
Can I just stop you there, Marcus? Because I think one of the important things to realise is that this whole model is supported by lots and lots and lots of beautiful granular decision making on the part of the federal and Supreme Courts throughout Australia on the unconscionable systems of conduct jurisprudence. And the unconscionable systems of conduct prohibitions in Australia have caused our courts to spend lots of years and time and grey matter working out how to identify and then characterise systems of conduct. Now, all of that work is there to assist directors and corporate counsel and so on to understand their job, how they can also identify systems of conduct and practices that have developed within their corporation. My book, The Culpable Corporate Mind, I have a chapter called Systems, Intentionality, Theory and Practice, which talks about precisely this. Now, it's from a litigator's perspective, so it's thinking about how do we identify and characterise a system of conduct. You know, what are the sort of evidential proofs that we look for? You know, what's the evidence inside the corporation? What is evidence outside of a corporation? Justice Gordon talks about this in her judgment in Productivity Partners as well, where she goes through, you know, all of the sources of evidence readily available to those in management.
Can you expand on some of these for our listeners?
So for example, you know, within a corporation, you might have training and induction practices that teach employees how to do their job. Again, not the glossy ones, but the ones that are actually delivered to the employees on the ground. The induction practices, the training on the job, the scripts that they're given for dealing with customer complaints, or the standard operating procedures as deployed on the ground. There's a whole bunch of internal evidence that will be available to the corporation for its own purposes. Could include internal contracts, could include incentives. Incentives are a really good one. Incentives tell you what matter to a corporation. Bonuses, you know, payment structures, you know, what are the criteria for being promoted.
Which may not be entirely consistent with the written policies.
Yeah, exactly. So, you know, for example, in Productivity Partners, all of the contracts with the recruiters said, oh, you must, of course, not engage in misleading conduct or pressure tactics or so on. But all the incentives were built around getting as many bums on seats for the start of the academic season as possible. So, and those incentives led the recruiters to engage in misleading conduct and pressure tactics and hand out free cash and computers and so on. So we look at things internal to the corporation, but of course there are also the consequences of the system of conduct deploying when it's an external facing system with consumers and so on. So consumers may be experiencing certain harms or price gouges. I mean, for example, this is a really simple one. There was a pain relief product. I'll use Voltaren as an example. So Voltaren had an arthritic pain relief product, which was contained in both its generic product and also its product that was significantly more expensive, but they both had the same active ingredient. Now, what Voltaren did was it removed the information from it did a rebranding so that it removed the useful information that told consumers that actually both products were good for relief of arthritic pain, and they put that information only on the more expensive product. Okay. Now, from a consumer's perspective, the removal of that, helpful information, and the rebranding to have an increased price and so on for what is functionally an identical product, that's all able to be proven simply from what you can see on the shop shelves. Actually, you don't even have to go inside the corporation to look for, who decided to do this rebranding campaign. Were there minutes of meetings? You don't have to go through. You just have to look at the end product.
Yes.
And you can see a lot about the corporate mindset there. And
yes.
I've written about why it is that through a systemic lens, that is not just misleading conduct. It's deceptive conduct. It's tricking consumers into paying more for identical product relief.
So you've taken us nicely to misleading and deceptive conduct. So there seems to be a couple of pillars where there's clear application for your concept: misleading, deceptive conduct, unconscionable conduct, and other corporate conduct, culpability. Do you see that as enough? And what I mean by that is, do you see the existing framework as being satisfactory enough, or do you think systems intentionality is going to expand as jurisprudence into its own tort, form a statutory basis of new liability? Where do you see this going in the next 5 to 10 years?
Well,
where do you hope this goes in the next 5 to 10 years?
It's a bit difficult to tell. I think that it's an analytical model. So normatively, it's in theory neutral. It just operates to help you find whatever corporate mental states may be required for corporate responsibility purposes, whether it's knowledge or intention or recklessness, is a good one. And I've explained in my writings, there's a chapter in my book called Modelling Corporate Mental States Through Systems Intentionality, which goes through this chapter and verse, precisely how you go about doing this. And I did at one stage draft a legislative provision which was designed to enable this to roll out more generally. But actually the High Court, if that continues to be followed, and Justice Edelman's and Justice Gordon's reasons are taken up for future purposes, and they were expressed generally, they arose out of the unconscionable systems of conduct jurisprudence, but if they were expressed generally as the way corporations think and act, that's how Justice Gordon expressed it. So if that's taken more generally, then it has quite far-reaching implications. And I suppose one of the things that I've started to think about more recently is how it might apply beyond commercial corporations to public juristic entities. So we think about Robodebt, for example. The Commonwealth is a public juristic person. It is a legal person, albeit not of the same type as you and me. The High Court has said on a number of occasions that the Commonwealth can be conceptualised as a corporation, albeit a particular type of corporation and not one that's created for profit. In Robodebt, you had an automated system that was deployed, which, when you look at it through a systemic lens, reveals some very troubling states of mind on the part of the Commonwealth if we conceptualise it as a corporation. So, as you would know, in that case you had an automated system that was fundamentally unfit for purpose, so that it would generate false debts against welfare recipients, because effectively what it did was it took a person's yearly earnings, divided it by 26 as a notional give rise to a notional fortnightly income. And that would have worked fine if welfare recipients had stable pay. But one thing we know about welfare recipients is that they don't have stable pay. That's why they are seeking welfare. So from the word go, Robodebt was inevitably bound to allege false debts against welfare recipients. And notwithstanding that, it was deployed, and notwithstanding the inevitable harms that would cause to already vulnerable groups, it was enforced through a huge range of supporting structures and systems and practices that were really egregious. Removal of limitations periods, reversals of onus of proof, enforcement through, various different debt collection agencies and through the Administrative Appeal Tribunal, but never appealed, because once the first instance decisions are not published, it's only if you appeal them they're published, and it becomes known that this system was unlawful. So I look at Robodebt and I think we needed a systemic lens to understand the culpability involved in that shameful saga. And we've just recently had the NACC say, well, individually we can only find a couple of scapegoats, a couple of people whose mindsets we can prove to have been, knowing and deliberate in relation to Robodebt. Scott Morrison, well, we're not going to be able to bring sufficient proof. But I always think, well, what about the Commonwealth? This was a Commonwealth, this was the might of government being exercised against the most vulnerable portions of Australian society. And I think, well, why aren't we saying that was not just a shameful saga, but it was a deliberate decision, corporate decision, a deliberate organisational decision to impose false debts on welfare recipients? And you might say, well, to what possible end? Well, it was a bloody good source of revenue, and it was pursued consistently with that purpose through enforcement mechanisms that were themselves unethical. So I just think, shame Australia, and I think time to have a fresh look at public entities as well as private.
But the underlying concept is certainly opened up by the recent High Court decision. I think Justice Gordon's
and look, I should hasten to add that neither Justice Gordon or Justice Edelman have expressed any views beyond the bounds of productivity partners, and it remains to be seen, of course, how future courts will interpret this and so on. But I think there's a lot to be said for, standing back from the various exculpatory narratives that we hear so commonly from our captains of industry and our captains of government, and say, well, let's just think about this for a moment. Organisationally here, we can understand the organisational values and purposes and so on quite clearly without necessarily having to listen to what's being said about what's being, the corporate cook can declaim any interest in producing pancakes, and yet we can see clearly the intention through systemic analysis in the way that I've described. The same is true of, commercial corporations, and I think also increasingly of public entities. The narrative that we get may be quite different from what's being deployed on the ground, and I think we need to have closer attention to the latter.
So as a closing point, Elise, what piece of advice would you give to in-house counsel who are now feeling overwhelmed at the end of this podcast when we've touched upon decisions like Star Entertainment and talked about the need to have regard to broader systems, policies and practices of the corporation to ensure that corporate counsel are discharging their duties to make sure the corporation's not engaging or potentially engaging in unlawful conduct? Where can they start?
Well, I think that we start around, the basics of assessing what you currently have. which is the audit side of things, assessing, what are your practices that are in place on the ground, and then analysing those to work out what their default settings are, and what this tells you about the corporation's values and priorities that have led to potentially problematic systems of conduct or practices being in place. So I'd start off with information gathering and then work on the program of rehabilitation. I think, it's a hard gig being corporate counsel, particularly if one's, because you're wearing a number of different hats, right? But I always come back to Justice Edelman and Casamatis talking about the fact that corporations have no interest in engaging in unlawful practices. And the role of corporate counsel is to look after the corporation's interests in remaining a lawful citizen, a good corporate citizen. And that is a tough gig. Corporate counsel also have overarching duties to courts, and there are a range of different ways they can feel pulled in different directions. But the short answer is that you have to gather your information and then start on that process of rehabilitation and understanding how to communicate to the governing board and to middle management to the extent necessary about this shift, I suppose, so that it's no longer, I think, plausible to put in place information barriers to prevent bad news reaching the top.
Yes.
That's a choice, and it's not a good one.
That ties in well with what Joe Longo was talking about in a recent episode, who, it's worth mentioning, Joe recognised your work in systems intentionality. And
it was ASIC and the ACCC's work in the unconscionable systems conduct prohibitions that gave me all the law I needed to create my model, actually.
Yes, if there's anything that should make in-house counsel sit up, it's that fact. And he was talking about the need for in-house counsel to step into the role, to be proactive. And based on what we've talked about, I think the audit, it's not a tick box exercise. It's not looking for what we do right. It's looking at how the system operates holistically and realistically. With that in mind, Elise, thank you very much.
My pleasure. Thank you for having me.